What is an appropriate education for students with disabilities under federal law? When do school districts have to step in and pay for students with disabilities to attend private schools? How many acronyms do we really need in education?
Yeah, seriously, WTF, man. So you're in for a big treat today, Chalk and Gavel listeners. Not only will we be digging into some special education law for the first time, but we're doing it with one of the best. Today, we're lucky to have Dr. Janet Decker with us to help us better understand the world of special education law as we explore the 2017 Supreme Court case, Endrew F versus Douglas County School District. This was a case that raised the standard for what qualifies as a free, appropriate public education for students with disabilities. So get your comfy pants on, folks. There's going to be a lot to digest in this episode.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, everybody. It's important to note that there's a ton to talk about when it comes to special education law. This is one of, if not the most heavily litigated areas in school law. Anyone working in schools, or most folks familiar to any degree with the special education process, is well aware of how complex it is. Tons of regulations, guidelines, requirements, paperwork, and on and on. So much of that has come as a result of countless court cases and laws over the last number of decades. There's absolutely no way that we can provide a complete coverage of all of the interesting things related to special education, but we hope that with Janet's help today, we can really start to paint a decent picture. So before we get into everything, let's take a little bit of time and introduce our guest today. Dr. Janet Decker is an associate professor in the Educational Leadership and Policy Studies Department at Indiana University. She is a special education law expert. She's written and edited numerous books, including The Legal Rights of School Leaders, Teachers, and Students, and How to Prevent Special Education Litigation. Janet is an advocate for increasing legal literacy, which is something that Chris and I are also extremely passionate about. She's won tons of awards and written a whole bunch of articles and book chapters, and it is truly an honor to have you with us today. Welcome to the show, Janet.
Hello. So great to be here. I am a super fan. I love this podcast.
Oh, thank you.
You know what? Before we start, I think it's a really good opportunity to mention a really cool organization here. So the Education Law Association, this is how we all met. This is how I met Chris. This is how I met Janet.
Mm-hmm.
It's how Chris and I realized that we had a lot in common, a lot of similar interests. It's where we sort of figured out that we wanted to start this podcast. It's a great organization. It's so supportive, such a talented group of folks who are passionate about education law.
Mm-hmm.
The membership is made up of professors of educational leadership and law, school and district leadership, attorneys who specialize in education law. It's a really amazing community, and maybe we'll talk a little bit more about it in upcoming shows. But if you've liked what you've heard on this show, then you might want to strongly consider becoming a member and joining us at the annual conference, which is in Orlando in early November this year. It's a really awesome, enlightening, inviting community. It's really welcoming to students as well. So if you're a graduate student out there who listens to this show and like the stuff that we talk about, consider looking into the Education Law Association. It's a great organization.
We'd love to see you there.
Yeah.
Yeah. And Jamie, I remember this podcast started because I sat down at the table you were sitting at breakfast one day at ELA a couple of years ago. And that was how we connected.
Yeah, totally. It really is it's my favorite conference to go to every year. And again, if you like the show, it's almost like you go to this conference and you get this stuff for 3 days straight, which is awesome. So anyway, that's that. All right. Chris, you got a bell ringer for us today?
I do. And this is an exciting one because it's an update on a case that we've been following now for a while. So this is an update on the case that's been kind of challenging Florida's law that requires teachers to use the pronouns that align with their sex assigned at birth. So this is the situation that we've reported on in the past about involving one of the teachers being A.V. Schwandes that we've discussed in previous episodes. So the plaintiffs here, one identifies as transgender and the other identifies as gender non-binary, and they're challenging this Florida law, seeking a preliminary injunction to stop enforcement of the law because they argue it violates the First Amendment as well as some federal employment laws. And as luck would have it, on April 9th, the trial court in this case actually issued a preliminary injunction stopping enforcement of the law against the transgender teacher. So you remember that A.V. Schwandes, so they were let go from their position, but the other teacher is still teaching. And so this order stops the state and stops the school districts from enforcing this law against her, from basically stopping her from reporting the pronouns with which she identifies.
And as we've talked about, Chris, one of the really interesting things about this is how these laws have kind of put schools in between a rock and a hard place, right?
Right.
You've got state law and these state regulations or directives or whatever that seem to be in conflict with federal protections.
Right.
Right. And so what we're seeing here is the courts essentially attempting to resolve that conflict.
Right.
Right.
Yeah. And that rock in a hard place is a great way to think about where school districts are within these kind of larger struggles. So the court found that the transgender teacher had a likelihood of success on her First Amendment challenge because the law impermissibly violated her free speech rights. And Jamie, to your point about, the courts having to kind of finally wade into these waters and adjudicate these issues, there's a couple things in this opinion that I think are really interesting. The first one speaks to that. So this opinion comes to us from Judge Mark Walker, who has issued a number of opinions enjoining or striking down various parts of various laws in Florida recently. So he issued an injunction stopping parts of the Individual Freedom Act, or the Stop Woke Act, as it's sometimes called. And so this opinion is kind of a continuation in this saga. And you can tell that Judge Walker is, let's say, he's getting tired of Florida shenanigans because he starts his opinion with the sentence, and this is a direct quote from a judicial opinion. "Once again, the state of Florida has a First Amendment problem. Of late, it has happened so frequently, some might say you can set your clock by it."
Okay.
So, I think he's sick of what Florida's been doing in regards to the First Amendment. So, I think that's a really interesting thing here, where you and I've talked about how at face value, these laws do seem to be problematic. Viewpoint discrimination, discrimination based on transgender status in violation of federal law. There's a lot of things that these laws have potential issues with. And here we're seeing that litigated.
Yeah, I think we should change the name of that opening segment to "What's Going On in Florida?"
Please, no. I know. I feel like we talk about Florida all the time. And I'm sorry. But, I think these are indicative of larger trends, and a lot of other states are navigating these issues. Florida just might have the dubious distinction of getting there first.
Yeah. Well, if you're not first, you're last.
Hey,
Look
call
at that.
back to our
Call
last
back
episode.
to the last episode.
I love it. Yeah. And so the last thing I'll say about this case is in the decision itself, another callback to a previous episode, the judge actually draws on Kennedy versus Bremerton to support the conclusion that the pronoun policy violates the First Amendment because the court compares the teacher here who identifies as transgender and Coach Kennedy and says that just like Kennedy's public prayers identify him as a man of faith, the teacher's use of feminine pronouns identifies her as a woman. And so the court is essentially arguing that just like the government couldn't silence Kennedy's speech, it can't silence this teacher's speech either. So that's just a really interesting thing here where we've got these are probably different sides of the ideological spectrum, right? But the principle is the same and it applies with equal force. So it's just really interesting to see how the Kennedy case is being used within employee speech context to kind of strengthen the rights of employees in relation to the state.
That's so cool.
Mm-hmm.
And if you want to hear more about what that Kennedy case was all about, we've got a 2-parter. You can go listen to it if you haven't already.
With Richard Katsky.
That's right. That's awesome. Very cool. Nice to see movement on these issues, and we'll kind of keep our eye on it now that this thing is potentially going to move forward. All right, Janet, you ready?
I'm ready.
Okay. So we're gonna talk about this Endrew F case. This is Endrew, not Andrew. This is Endrew, Endrew, Endrew F versus Douglas County. So Douglas County out in Colorado near Denver. We'll give you just a brief background because we're going to talk a lot today about a lot of really important aspects of special education law that are sort of referred to in the Endrew F case. And so we're gonna kind of use the Endrew F case as sort of a vehicle to talk about a lot of special education law, right? So Endrew F was a student with autism who attended public school in Colorado. His parents argued that the Individualized Education Plan, or IEP, here we go with the acronyms.
Number one.
Now, yeah.
We should have like acronym bingo for the listeners. How
That
many
would be a great
are we going to
idea.
use?
Oh, we should do that. Like maybe I should do that in my classes now.
I love that idea.
I do a relay race where we have the acronyms on the board and they compete against each other and trying to, because you have to know the acronyms, right?
Yeah. Oh, that's cool. All right. So acronym number 1, IEP. Well, that's acronym number 2. Acronym number 1 is WTF.
Oh, fair. How could I forget, Jamie?
Sorry. Okay. Yeah. So, all right. So his parents argued that the IEP that was provided by the school was not adequate and did not provide him with, here's acronym number 3, FAPE, the free, appropriate public education that all students with disabilities are
entitled.
Thank you. Entitled to. And
under
the IDEA, acronym number 17, the Individuals with Disabilities Education Act. So what happened here was Endrew F's parents pulled him from the public school and sent him to a private school that specialized in serving students with autism. And this was not a cheap endeavor. Like we're talking, $75,000 roughly a year?
North of $70K, yeah.
Yeah.
And it's just increased since many years ago.
Yeah. And so this was 2017. Well, that 2017 was when the Supreme Court ruled on it. But all of this stuff happened prior to 2017. So it's been a while.
When the court took up the case, I think Endrew was 17 when the Supreme Court did.
Wow. And Endrew was diagnosed in 2nd grade, I believe.
I think he was diagnosed at age 2.
Oh, sorry, that was the 2. Yeah, not 2nd grade. He was diagnosed at age 2. Yeah. So again, the short version was that he was diagnosed with autism. The parents did not feel that his IEP provided by the public school was providing him with his free, appropriate public education that he was entitled to under the IDEA. And so they pulled him, sent him to private school, and then they sued the district for to have that covered.
Yeah, they wanted tuition reimbursement. And, it was the issues that he was having at school. He was at public school and it was in fourth grade. And some of the issues were really serious, really scary stuff. So, I heard in an article that his mom was interviewed in that, there's all kinds of really scary behavioral issues. His problems at school, he'd scream, he'd climb over furniture. He sometimes would run off school property. So, she was being called to school every day to calm Drew down and twice she had to take him home. So it wasn't just like minor issues that he was having in his placement. And it was, year after year, they were seeing some of the same goals appear on his IEP, where they didn't think his academic or his functional and behavioral progress was advancing at all. They were really worried about his safety and his ability to learn in the public district.
Yeah, and that's one of the things about an IEP, right? Like these goals need to evolve, right? Year over year. They can't just be copied and pasted, and especially if they're not being met. And
they're not cookie cutter, they're individualized. Yeah.
Right.
Yeah. So maybe now's a good time to kind of take a step back and talk a little bit more broadly about the IDEA.
Before we do that, Chris, I think it's also important to note that once Endrew got into this private school, the issues, this school was able to work with Endrew in a much better way than the public schools were able to. And Endrew's performance, or how would you describe it, Janet?
Yeah, I think he was able to learn. His behavior was really impeding with his ability to learn, and was also impeding with the students around his ability to learn. It's not just about him, but it's about the whole classroom environment. And so a big issue was that the public school district was not implementing positive behavioral interventions and supports. You could refer to that as another acronym, PBIS. They weren't doing enough about his behaviors. They weren't teaching him about behaviors. And so the private school specialized in applied behavior analysis, or ABA, another acronym, and really got his behavioral, they really taught him about behavior. And so those impeding behaviors were lessened. He didn't have the same kind of anxieties that he had in the public school, and he was learning, he was progressing. His parents were really pleased with the progress that he was having in the private school.
Interesting.
Well, yeah. So just to kind of give some more context to what we're talking about. So, baseline, the IDEA, Individuals with Disabilities Education Act, guarantees every child with a disability, with a qualifying disability, got to put that caveat on there, a free and appropriate public education, right? And so that's kind of what this whole case is about, is whether or not Endrew was receiving an appropriate education sufficient to provide him FAPE at the public school, or if the public school was, designing an IEP that was reasonably calculated to provide FAPE. And so that question of, that substantive standard is really what drives this case. And I think, Jamie, you mentioned the IEP and the I always mess this up, individualized education program, right?
It could be program or plan. I think in IDEA, I think they have it listed as program, but somebody could check me on that.
Yeah, so the IEP has to include specially designed instruction to meet the unique needs of the child with a disability. That comes straight from the statute. And it also has to include related services, which are services that are required to assist the child to benefit from instruction. So that's kind of what the parents are arguing here, right? They're arguing that the IEP that the public school created to meet their requirement under federal law didn't have enough in it to adequately provide Endrew with the services he needed to address his behavioral challenges, and also to, design his instruction to meet kind of where he was and what he was capable of. Is that kind of that's the parents' argument here, right?
Yes, that's what I would say.
Yeah. And I think the big objection they have to this IEP too. So, we've talked about IEPs. You have to write these every year, right? Like you have to do an annual review of the IEP every year. And it sounds like from the case here that the parents were kind of objecting that they were basically recycling. I forget who said it. They were copy and pasting, right? The prior goals. And so they weren't evolving as the child was, as Endrew was making progress, which is another big aspect of the IDEA is monitoring progress towards these goals and, creating benchmarks and all of these different check-ins to basically ensure that children with disability are making progress towards these goals.
Yeah. His dad, Joe, was quoted to say, we didn't want to pull him out of school. We didn't want to take the district to court. We didn't want to do any of this. But they just pushed them into a corner. And then his dad said, we had to get what Endrew, was entitled to by law and what he needed.
Mm-hmm. And, and this hits a little close to home for you, right, Janet, in terms of what experience this child had moving to this school?
Absolutely. I mean, I was a teacher teaching students with autism at a private school that's very similar to the school that Endrew eventually attended, his private school. It was a school focused for students with autism. Kids started at preschool and they went and with the school as adults. And the type of intervention was applied behavior analysis, and saw districts paying for students from public school districts to go to this private school because it was the appropriate placement. Mm-hmm. And so when Endrew was decided by the Supreme Court, it was so interesting to me because I had this exact experience to where that's really the whole reason I went to law school, was because I saw the inequities that some families were able to get certain levels of intervention for their kids, and based on what social capital they had or what economic capital, or in a lot of situations where they lived. And that's, we'll talk about later, but the geographic disparities based on what the legal standard was. Mm-hmm. And so, I saw these inequities and really wanted to learn, well, how could some places define appropriate what kids are entitled to under the law differently than what I was seeing at my private school. And so, this case is very similar, and I was so grateful that the Supreme Court took it up, and so grateful that we also have a case that's about behavior. Behavior is so important to learning, and really having educators getting the supports they need to learn how to help kids learn about proper behavior is really, the first step before learning. So. Just really, this case is definitely aligned with a lot of the reasons why I went into advocacy and really, specifically care about students with disabilities and specifically students with autism and their families so much, because I saw firsthand a lot of the struggles that they faced in getting the type of services that they were entitled to and what they needed and what society needs. We need to have students receiving appropriate educations, and that's only going to benefit all of us.
Yeah, I couldn't agree more. And I think that, we talked a little bit about this before we started recording, but like so many of the things that we're seeing in a lot of our classes of prospective school administrators is there is such a lack of understanding and awareness. And it's not necessarily anybody's fault. This is not to place blame anywhere, but
no.
The world of special education is so complicated and it's so multifaceted, and in addition to all of the federal laws and regulations and guidelines, states have their own, and it's a lot to keep track of. But again, like we said, this is like the most heavily litigated areas in school law, and as a result, the procedures and the everything that's in place is like, there's a lot, right?
Absolutely.
And it's really important for educators to understand all of these different components, right?
Right. When I was a practicing attorney, I did a ton of special education law. And, I litigated special education law. I had the Ohio regs bookmarked on my browser because I looked at them every single day. And, I was the attorney, right? Like, I still had to look stuff up.
Yeah. And think about it. The teachers, some of them, so, in their preparation programs, they might identify as either going into special education or into general education. So I ask my students, I say, how many of you are special education teachers? And typically only a couple of them raise their hands. And I say, no, you're wrong. You are all special education teachers. You all have to follow the law. And students with disabilities are in the general education placement. That's the preferred placement. And it's more than 80% of the students with disabilities are in general education classrooms. So all teachers need to know about this, but they're not necessarily getting prepared. And so they might be uninformed, or they might be asking other teachers, and they might be misinformed. But ignorance of the law is no excuse. And by the time a situation gets to an attorney, a lot of times it's too late. They have to know, they're on the front lines. They have to know not to make the mistakes early on.
Right. Yeah. If I don't hear about it beforehand, all I can do is help clean up.
Yeah.
Absolutely.
And Janet, let's talk just a second about what you just mentioned. Why are, from a legal standpoint, most students with disabilities in general education classes?
Well, the law requires it. So the IDEA requires students to be in the least restrictive environment. And so they're supposed to be in, a placement that is least restrictive. They're supposed to be meeting the standards that general education students are meeting and exposed to those standards, whatever is individualized, determined to be appropriate for them. So yeah, it's under the law as well, is that we have, sometimes people refer to it as inclusion or mainstreaming, but LRE, another acronym, least restrictive environment, is part of a really important cornerstone of the IDEA as well.
Yeah.
I can't remember which case it was, but there was a case that really dug into basically the fact that you can't just, because a kid has a disability, you can't just pull them out. You can't just keep them, and say, we'll teach them, but we'll teach them over there. Right.
Yeah. And that, I think, going back to kind of like the justification for the IDEA when it was passed in the 70s, like it was very much about ensuring that children with disabilities had access to public education and that they weren't kind of excluded or sent off into their own classrooms, which is why this question of access, this question of eligibility, and this question of, what's the appropriate placement are so important, because the IDEA expresses a strong preference. And, in fact, it's kind of the default that you can deviate from if you have sufficient justification for inclusion of students with disabilities in the general education classroom, which is why I always joke with students that if you can understand this sentence, you understand the IDEA. And let's see if I can get it right. The IDEA guarantees students with disabilities an IEP that is reasonably calculated, and we'll get into this in a second, for a student to make appropriate progress with SDI, related services in the LRE. And I think I put just 6 acronyms in that sentence. I don't know. I lost count. But like, if you understand that sentence, you pretty much have the IDEA under wraps.
Sounds good to me.
I think by the end of this episode, we should craft
an entire
I didn't put
FAPE
sentence.
in there. I should have put FAPE in there.
No,
we need to redo this.
We need to have an entire sentence that is only acronyms.
So the IDEA guarantees an IEP that provides FAPE with SDI and related services in the LRE.
Okay.
I think that was it. Was that it?
Sounds good.
How much did I miss, Janet?
I think that's good. I think that's good. I'm a big proponent of PBIS, so I might try to put that one in there too. But
well, and then you've got the MTSS, and
exactly.
Oh boy. Okay.
So this is obviously a lot to kind of absorb, and there's a lot to go on, or there's a lot going on within special education law, particularly the IDEA, just because it's such a complicated statute. I know we're joking about the number of acronyms that we have to deal with, but all of those are really important concepts. And so not only are these important concepts, but the IDEA itself also has a lot of like procedural requirements with like timelines and deadlines and things that schools and teachers have to meet as well. And so all of these things, and we've kind of already kind of alluded to the challenges with legal literacy related to special ed. And you can imagine how, given the complexities here and just the nature of the interest, right? Like we're dealing with parents and their children and public schools, and, they never seem to have as many resources as we might want. So there's always going to be conflicts here, which is why the IDEA has a number of actually dispute resolution mechanisms built into it. So parents can do mediation. They can, as they did here, bring a due process complaint against the district. And so, I mentioned when I was practicing law, I handled a number of these due process complaints when parents were upset about kind of the level of services that their kiddos were getting in school.
Yeah, I just mentioned that another reason, and I try to put it in context for people that, it's not necessarily about school districts not doing what they're legally required to do, or parents expecting more than their, kids are legally entitled to. It's a policy problem that we have this federal law that's never been fully funded to the levels that Congress promised back in 1975. So it's a underfunded mandate. So when you have an underfunded mandate, you're absolutely going to have disputes that are going to arise between parents and school districts.
Yeah, and that's a really good point. I think, I don't know the exact numbers, but it's not just not fully funded. It's only funding like a fraction of what it actually costs.
Oh, yeah, like 14%. And I think Congress said that they would provide 40% back in 1975. Wow.
Yeah, it's an expensive endeavor. But, thinking about the values too, like I had a professor joke that the IDEA doesn't guarantee every child a Cadillac.
Yes.
It guarantees them a Civic.
Yeah, there's actually even a lower court case about that. That was the language that the court brought up. They said, it's not a Cadillac, but it's a Chevy, and that was language from it. And so, of course, as parents, any of the listeners who are parents and all of us know, we want the best for our kid. We want the Cadillac.
Right.
We don't want the Chevy, right?
Yeah.
But to figure out what is it maybe it's not a Cadillac, but it's not a Chevy either. And so that's a big, that's a great analogy of what Endrew was all about.
Right. Yeah, because within the IDEA, we often talk about like procedural issues and then substantive issues. And procedural issues, like, the IDEA has a lot of very specific things you have to do and specific timelines for when to do them. But on the substance side, that's kind of this question about what level of education children with disabilities ought to receive. And that's what Endrew F is all about, because the parents wanted something more than what the district was offering.
The district wasn't even providing the Chevy.
Right? Exactly.
Right.
But he went to a place where he got the Cadillac.
Yeah.
Kind of setting the context for the parents' due process complaint here in Endrew F. This is actually the second time that the Supreme Court has dealt with this question of what the substantive standard is under IDEA for FAPE. And the first case that the Supreme Court kind of dealt with these questions was Board of Education of Hendrick Hudson Central School District versus Raleigh. And this is a 1982 case. So just a little bit of background on this case, because it's really important for the court's ultimate decision. So Raleigh was a first grader with a hearing impairment, and her school district offered her an IEP where she was going to receive education in the gen ed classroom. She spent time each week with a special tutor, had a speech therapist. The district had some assistive technology, which is another thing that the IDEA protects, and where the teacher was going to wear this wireless transmitter, and then Amy was going to wear a hearing aid designed to amplify the teacher's voice. So the district had all this stuff in the IEP, but the parents, going back to our conversation about Cadillacs versus Chevys, they argued that the IEP should include a sign language interpreter in all of Amy's classes, and the district denied that request. And so that led to due process, lawsuit, gets all the way up to the Supreme Court. And the big argument in Raleigh is, what level of substantive requirement does the IDEA provide? And we had kind of different ends of the spectrum. One argument was that there is no substantive requirement under the IDEA because the IDEA is just a procedural law. It just protects the process of getting kiddos into schools. On the other hand, there was the argument that the IDEA guarantees children with disabilities an education that's going to maximize their potential. And so we had these two huge, ends of the spectrum. And the Supreme Court kind of strikes a middle route in Raleigh and says that there is a substantive requirement under FAPE that the districts have to meet. And it's one that is characterized by an IEP that is, this is the quote from the court, reasonably calculated to enable the child to receive educational benefits, which for people like Amy, the student in Raleigh, is an IEP that's reasonably calculated to enable them to achieve passing marks and advance from grade to grade. And because Amy was making excellent marks, she was advancing from grade to grade, she was actually outperforming a lot of her typically abled peers. The court concluded that the IEP there was appropriate. It satisfied this standard. And so after Raleigh, which is kind of where Endrew F comes in, there was a lot of disagreement. Janet, you already kind of alluded to this. There was a lot of disagreement in the lower courts about what Raleigh meant for this substantive standard. Some applied what they called the de minimis standard. Other applied what was called like a meaningful benefit standard. So even within this standard, there was an argument about what level of education had to be provided to students with disabilities.
Yeah, what was appropriate. And that de minimis standard was, just to kind of put it into other words, a real trivial measurement. It was just, some education benefit, and it was a low bar for districts to have to meet.
Right. And we'll talk about that with the 10th Circuit here in this case, right? Like it's as long as it's not nothing was pretty much it is. As long as it's something and not nothing, you meet the standard. And that's a very, very low bar, right? Like that's almost, I think in the language of the court, which we'll talk about in a second, it's almost no standard at all, right?
Yeah.
So I think that's a perfect segue into the case.
Sounds good.
So just to kind of back up and remind our listeners what all of this was about was this student who was diagnosed with autism at age 2. Again, that's one of the categories that's within the IDEA. Endrew was going to school in a public school system, and every year that he was in that school system, he had an IEP. So Endrew gets to about 4th grade, and his parents aren't happy with the progress.
Mm-hmm.
And the court was quoted as saying, although Endrew displayed a number of strengths, his teachers described him as a humorous child with a sweet disposition who showed concern for friends. He still exhibited multiple behaviors that inhibited his ability to access learning in the classroom. So as Janet talked about earlier, he would scream, he'd climb over furniture, he'd run away. He had a difficult time in school. So his parents pulled him and sent him to Firefly Autism House, which was a private school that specializes in children with autism. And it cost, $70 some odd thousand to send him there, the Cadillac.
I don't know if that's like in educational terms, that might be like a Ferrari. Like, I don't know what's above Cadillac. Bentley?
Bugatti? I don't know.
Well, I don't know if it's a Bugatti. That's at the very, very tippy top, right?
It's good. And think about it like this too, like $70 some odd thousand for a student per year. Like, think about what this case is about. This case is about getting the public school system to pay for that education, essentially, right?
And, cost can't be part of the equation. So it might be that isn't the Cadillac or the Ferrari. It might be that that's what Endrew needs. Maybe Endrew needs intensive early intervention, and then across the spectrum of his life, he's not going to need that anymore. So, we do have to look at it from an individualized standard. Like it's expensive, but maybe that's what that child needed. And also kids that have really serious medical and other conditions, sometimes it's really expensive intervention, but it's what they need to be able to access an education.
Right.
Yeah. And I think my only point for mentioning that was just essentially to call out that in this particular case, I mean, that's a lot of money.
Oh, yeah.
For a public school system, as tight as budgets are and things like that, to spend on one student, right? And so that's, that's all I wanted to kind of mention about it, just kind of think about it from that perspective. But like you said, Janet, if that's what that child needs to meet that appropriate standard, then that's what that child needs to meet that standard.
And I'll just say, from my personal experience, saw, kids, especially the earlier intervention, the more intensive intervention they got earlier, some of the kids would transition out of needing much intervention at all. Some of them even lost their diagnosis of autism. Some of them, would have spent their entire lives being nonverbal, but for that intervention. So these are really important life skills that kids need. It's all individually based, but, it might be really expensive early on, but it might be in society's best interest to invest in kids early on so that you don't have to unlearn behaviors. You don't, and so that kids know how to talk and they're not exhibiting negative behaviors because that's their only way to communicate.
Right. And that's a policy decision that the IDEA makes, is that, look, it guarantees students a appropriate public education. And it doesn't say unless it costs too much, right?
Right, yeah.
Yeah. And so what led to the case here was Endrew did really, really well at this Firefly Autism House. And so what happened was his parents went back to the school district. They met with the school district again, and the district offered a new IEP, but the parents didn't like that. They didn't, they rejected that new IEP. One of the questions that I had, and I don't know if you know the answer to this, Janet, is I wonder if either the parents or Firefly communicated with the school district on the strategies that were working really well for Endrew at Firefly, so that the school district could potentially incorporate those same strategies when they redeveloped the IEP, or when they offered a new IEP. I'm not sure. Do you know?
So according to his mom, they went back to the school district and they said, he's had this huge growth, and they went back to the school district and they said, hey, let's take what we've learned at Firefly and let's apply it to the public school district. And according to his mom, the school district's attitude was like, no, we're going to do the same old thing. And here's the same old information again, is what she's quoted as saying. And so, and I know they had previous experiences where they had a therapist, I think it was probably an ABA therapist, come into the public school district, and eventually the school district didn't want that person in that environment. So I think they'd had this history of trying to implement some of the strategies that they were learning would work with Drew, but they didn't feel like the school district was real receptive to that. And so they mentioned they got backed into a corner. They didn't want to go to court, but they felt like they had to go to court.
And I mean, I guess one thing that isn't as clear, because that seems to be coming from the perception of the parents,
right?
Like what we don't know as much about is what the district's position actually was. Were these requests, for example, something that they just simply did not have the resources to offer?
Right.
Or were they more actively trying to back this family into a corner? I'm not sure we know that.
Or, the standard at the time in the 10th Circuit was the de minimis standard, right? So like, as long as they were applying some benefit, the district.
Yeah, that could be it too, right?
It could very well be that they thought that the parents were asking for too much, and that's what the Supreme Court had to decide,
And that's something that I think is really important in the special ed cases. And just to think about in general with the special ed process, is the IDEA is structured in a way to ensure that parents and the district are kind of partners in developing the IEP and making decisions for the child's education. And so like, there are always situations where parents and districts don't see eye to eye. And that kind of, Janet, to your point, like that kind of accumulates over years and years and years, where you kind of burn those bridges and you harm those relationships. And then they kind of come to a head at one point, which is why, like, so much of special education law and education law in general is built on relationships, where like,
Absolutely.
If you can have those great relationships and have productive relationships where everyone feels valued and heard, like you can avoid a lot of this stuff.
I absolutely agree.
I say that all the time it's almost like the caveat to every single class that I teach. And if you want to avoid these situations, build healthy, meaningful, positive relationships with your families.
Pound of prevention is worth a pound of cure. Is that the saying?
Yeah. So, so that's what led to the lawsuit. The parents were not, felt like like Janet said, felt like the district had backed them into a corner, and they thought that the school district should reimburse them for Endrew's tuition.
Yep. And so they file a due process complaint, which starts as an administrative complaint and makes it all the way up to the Supreme Court, and then back down to the trial court, and then back up to the appellate court before it finally gets settled. So start keeping score, because we've got a lot of decisions in this case that we got to talk about.
Is this going to be another two-parter?
How fast do you want me to talk? So the underlying issue in this entire case it all boils down to this question over whether or not the district provided an adequate IEP for Endrew, because whether or not the IEP was adequate determines whether or not the parents are entitled to reimbursement for the costs of their unilateral placement of Endrew F into this private school.
That sounds simple enough.
Yeah, done. I think, we could wrap this up in 3 more minutes. Except...
Well, I think it's that was also, a big reason why I went to law school was the idea of I thought that word appropriate. I could define that. But it was the case law and these legal standards that I had no training in. And so, you can't fault teachers or sometimes school administrators for not knowing all the intricate details of the law to be able to know what the standard, how to define that word appropriate and how the standards differ from state to state.
Right. And it's something, and I think I've used this phrase on this podcast before, it's a squishy term, right? It is, it's an I know it when I see it kind of rule.
Mm-hmm. Yep.
So we've got this due process complaint. We go before the administrative law judge, which is the first step of these due process cases. And the ALJ, acronym alert, says that the school's IEP was sufficient. So the school district wins round 1. So the parents don't like that answer. And so they appeal that to the federal district court. So now we're at the federal trial court level. And the district court looks at this and affirms the administrative law judge's decision. So now, if you're keeping score at home, parents are 0-2. The district court essentially says that Endrew's performance under his past IEPs did not reveal immense educational growth, but the court concluded that the annual modifications to the IEP were sufficient to show a pattern of, this is the important language, of at least minimal progress. And so this gets up to the 10th Circuit, which at the time interpreted the substantive requirement of IDEA under Raleigh to only require some educational benefit, meaning an educational benefit that is more than de minimis. And so when this case gets up to the 10th Circuit looks at this and says, Endrew's IEP was reasonably calculated to provide some benefit. As long as it is some benefit and not no benefit, that's enough to satisfy the IDEA. So we've gone through 3 levels of judicial review already. The parents are now 0 for 3, but they're not done because they appeal it to the Supreme Court. And I don't think we've had one of these yet, Jamie. In a unanimous opinion, the Supreme Court reverses the 10th Circuit.
Yeah, is this our first unanimous Supreme Court decision?
I think it is.
Look at that.
Yeah, I mean, we've never made a mistake on this show yet. So but the Supreme Court takes this up, and in a unanimous decision, which is always good when we can say that about the Supreme Court, they conclude that the 10th Circuit's de minimis standard, the some benefit standard, is the inappropriate standard for determining what constitutes a FAPE under the IDEA.
Which is really a big deal.
Huge,
because
right?
This was a circuit split and the majority of the circuits were using that de minimis standard. So this was a big deal that unanimously they decided to change that standard.
Mm-hmm.
Or at least clarify it.
Right. I think the Supreme Court would say that it did change the standard because there's language in here where the court basically says, the standard from the some benefit standard, the one we're articulating here is a sharp departure that requires substantially more than that, because that's what the IDEA says and that's what the IDEA requires.
Yeah, I even wrote down one of their quotes, that they said applying that minimal standard would be, quote, tantamount to sitting idly, awaiting the time when students with disabilities were old enough to drop out. So they really didn't like that de minimis standard at all.
Yeah. Which, I mean, the fact that it's unanimous just kind of shows you how much they dislike that. Usually you expect at least 1 or 2 judges to be like, I disagree about this little thing over here, so I'm going to dissent. So getting into kind of how they think about this. So again, the big issue is, how do we define FAPE? What do we mean when we talk about a free and appropriate public education?
And specifically just the word appropriate part, right? I think the other part, the free public, that isn't wrestled with very much, right? It's just the appropriate, what is appropriate? Because once we figure out what that is, then we know we know the free and the public part, right? We know who's paying for this.
Right. Yeah. And so trying to think about how to define what is an appropriate education, the school is arguing that they satisfy the FAPE requirement when the IEP is reasonably calculated to provide some benefit as opposed to none. So that's the school's perspective. They're kind of sticking with what the 10th Circuit said. The district, to do this, kind of points to language from the Raleigh case, that 1982 case, where it seemed to suggest that like the court was just looking at whether or not there was a benefit or not. So it was kind of this binary decision, and they weren't looking to evaluate the amount of benefit offered. And they kind of double down on that, the district does, and argue that the goal of the IDEA was to open the door of public education to children with disabilities. It wasn't necessarily to guarantee them any particular level of education once they got inside. The Supreme Court isn't having it. They don't like that argument. They, quickly kind of say that that's way too narrow of a reading of Raleigh. You're just cherry picking quotes from Raleigh, where that's not really what we said in that. So if you look at Raleigh in context, like we were really looking at ensuring that children with disabilities get the supports that they actually need. And like Amy Rowley was actually doing better than her classmates. So like it wasn't a question of like, did she get benefit or no benefit? Like, was she getting the right education was really what we were concerned about. So like the court basically says like, we didn't answer this question in Raleigh, and you probably shouldn't read the case like you're doing, which is just interesting how like courts use these cases. And that cherry picking language thing, I think, is really interesting because so much of the law is just interpreting what other people have said about it. And there's always a lot of room for interpretation.
That's fun.
Mm-hmm.
Yeah, it means we'll never run out of things to talk about, Jamie.
That's right.
Yeah. So then the court articulates, so it kind of rejects both the parents' position and the district's position. And they say, here's what we think FAPE means. The court essentially just kind of starts and ends, to Jamie, what you said earlier, like they start and end with the text of the IDEA. They say to meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make appropriate progress in light of the child's circumstances. So they just kind of pick up that language of appropriateness. Obviously, we've got to define what that means, and that's kind of the thrust of the rest of their opinion. But they get rid of this benefit standard, whether that's some benefit, meaningful benefit, more than de minimis benefit. They jettison that and instead look at whether or not the education provided is appropriate. And this is a forward-looking standard because we're looking to see if the IEP that you write is reasonably calculated. So it's prospective, it's not looking backwards, and it's focusing on progress because that's what the IDEA is all about. It's about ensuring that students with disabilities are able to make academic and, personal advancements towards their learning goals.
And I think it shows a shift in the trends in special education law that, initially, say 50 years ago, it was about access.
Yeah, just get them in.
Yeah, open the doors. And now we see that it's about the quality of education, about the progress that students are making.
Yeah. And the court even calls the IDEA an ambitious piece of legislation because, of that exact reason. Like, they knew that this was going to be a heavy lift given the history of discrimination against these groups. And so to kind of show that we're getting to different points where now we can kind of focus on different aspects of that ambitious law, I think, shows that the IDEA is working.
Mm-hmm.
And so the court looks at this and says like, okay, well, if the standard is appropriate progress, what does appropriate progress look like for students with disabilities? And I think this is something the court kind of really struggles with because everything in the IDEA is all about individualization. And so it's really tough to articulate kind of a broad standard for what constitutes an appropriate education for every child with a disability. And so they kind of give us this kind of almost bifurcated test where if it's a child who is fully integrated into the gen ed classroom, we basically apply Raleigh and we say, as long as the IEP is reasonably calculated to enable the child to achieve passing marks and advance from grade to grade, that constitutes appropriate progress for that child, because that's what we expect for everyone in public education. Mm-hmm. We hope that we provide an education that, meets the learning standards, allows them to be successful, allows them to progress from grade to grade. Where it gets tricky, though, is for students who are not fully integrated into the gen ed classroom. And this is where a lot of the arguments in this case take place. The school is arguing that for those students, de minimis is enough, for the same reasons that we talked about earlier. Obviously, court doesn't necessarily like those arguments. But the parents, on the other hand, are arguing that the FAPE requirement for them, for these students, ought to be the level of education that allows these children to achieve academic success, attain self-sufficiency, and contribute to society that are on kind of essentially substantially equal footing to the opportunities provided for children without disabilities. And so,
yeah, the parents really wanted an equal opportunity standard to be put in place.
Right, which is part of what the family argued in Raleigh, too. And the court kind of looks at this and, again, kind of strikes a middle road where they say that based on the language of the IDEA, there's nothing in the IDEA that requires kind of peer referencing. It's all about individual students. And so we can't really look to other students to articulate what is appropriate for any given student. And so instead, they say that the educational program for children who, like students in the gen ed curriculum, they deserve ambitious goals. They deserve a program that is designed to help them meet challenging objectives. And so all of this kind of, they're basically designing parallels between students that, are sensitive to the child's individualized circumstances. And so they articulate this standard where the educational program to provide FAPE has to be appropriately ambitious in light of the child's circumstances, just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. The goals may differ, but every child should have the chance to meet challenging objectives. And so that's what the court comes down and says is required to provide children who might not be in the gen ed classroom a FAPE.
The court definitely said that the IEP must be reasonably calculated to allow a student to be involved in and make progress in the general ed curriculum. So they were concerned about these challenging objectives. And, the real key test, the real key language from the court's opinion was that schools must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances.
Right. And so it's very individualized, right? Like it's a general standard that is applicable to all children, but what it looks like for any individual child is going to be context specific.
Yeah.
And that's what the IDEA is all about, right? Like an individualized education plan. There's so many instances in the language of IDEA where they're pointing to those very specific individualized considerations.
And listen, that's a good thing for all of us to have, at the front of our minds when we're educating everybody, right? Like, it's not about putting out cookie cutter scripted lessons. It's about differentiation, right? It's about meeting the kids where they're at. And not every kid is at the exact same place, right?
Right.
And so one way I look at it is this is another a more detailed mechanism that allows us to do what we should already be doing and sort of guarantees that is being done for this population of students that often have more trouble accessing the general curriculum, right?
Right. Who have different learning needs.
Absolutely.
Yeah.
Mm-hmm.
Yeah. And it helped just clarify, I think when Raleigh didn't have the clarification for students who are unlike Amy Raleigh, then courts and school districts thought, well, if it's not best, well, it's minimal. And the court at least clarified that no, it's not minimal. It's ambitious. It's challenging objective. It's progress. So there's been some question about how much of a game changer this case was for districts, and so for districts who were doing it where they were, that was their standard of appropriately ambitious and ensuring that there were progress monitoring and not having the same goals appear in IEPs year after year, and districts who were taking care of kids impeding, challenging behaviors, wasn't so much of a game changer. But then for other districts that weren't, or for parents that needed to have some more clarification to bring forward this language from Endrew, it has been a game changer. It has clarified. It's probably settled a lot of cases that would have gone farther. And for Endrew, maybe we should talk specifically about Drew's family. What happened with them?
I've got that in my notes for what's next, because the Supreme Court, the trip to the Supreme Court is not the end of the story, right? But the last thing I'll say about the Supreme Court's decision is it includes this really interesting line. So thinking about the burden of school districts, they have to meet that substantive standard. And the court goes on to say that, when courts are looking at that to see if the school has met that standard, it's not an opportunity for the court to second guess educators. We're still relying on the educators' expertise and professional judgment. But they do say that when there are conflicts around whether or not a school has provided an appropriate education, schools should be able to offer cogent and responsive explanations for their decisions that show the IEP is reasonably calculated to enable the child to make progress appropriate in light of his circumstances. And I think that's a really interesting point here, too, where it's not just like you got to make sure you're doing this, but it's also you have to make sure that you have a cogent and responsive explanation. So do you have the receipts? Can you back it up to justify your decision? And, I think that's
a theme on this podcast is reminding listeners, save your receipts.
document.
Yes.
But yeah, let's talk about what happens to this case after the Supreme Court gets a hold of it.
What happened?
So the Supreme Court doesn't apply its new standard to Endrew's situation. They just kind of articulate it and say, hey, we're not the right people right now to apply this standard. We're going to remand this down to the circuit court. So keeping score at home, where the parents are now 0-3-1. I'm calling that a tie. They don't win, but they don't lose. The 10th Circuit looks at this and says, hey, we're not the right people to apply this new standard either. Trial court, your turn. And so now we're 0-3-2. And so it gets down to the trial court, and the trial court determines that the IEP was not reasonably calculated to enable Endrew F to make progress appropriate in light of his circumstances. So the parents are now 1-3-2. This is our 6th adjudication in this case.
They were quoted as say that they lost a lot of the battles, but they won the war.
That's exactly right.
And so just to kind of put it in layman's terms, so what happened was the Supreme Court developed their standard, this sort of new standard, right? But they didn't decide on whether or not that was met. Okay, in this particular case.
They didn't apply it to Drew. They said, okay, we're going to pass the buck back to the lower courts there. And they heard the details of the case initially. We haven't heard those details before us. We're going to let that court decide.
So basically they're saying,
right,
now you can take our new standard that we've created and apply that and figure out and go back and do your thing again.
Yeah, it's the you did it wrong, do it again.
Or no, it's not you did it wrong, do it again, right? It's more of like, we just changed the rules on you, do it again.
Well, it's the you should have known these were the rules in the first place, so I can't believe you did it wrong.
Oh, okay. Yes. Okay. We got there.
Well, no, I mean, that may be a little disingenuous, but that's the gist of it, where it's like...
Yeah, like the rules have changed.
Yes. Yeah. Okay.
So the district court looks at the IEP and says, looking and applying the right standard, this IEP is not adequate to allow for appropriate progress because you're just carrying over the same objectives year to year. There's not enough modification. You're not putting in any formal plans to address the student's behavior, all of these things that we kind of talked about. The court now looks at this and says, you know what? That is inadequate under the new standard. So district, you are required to cover the private school tuition. And here's a really important piece of this entire thing. The court also orders the district to pay the parents reasonable attorney's fees and litigation costs because the IDEA allows for fee shifting for prevailing parents. So if parents win...
Any guesses how much that was?
Well,
I know the answer.
We know.
I do too. It's amazing.
It is spectacular. If you thought that spending $70,000 on a student's tuition is a lot, what they ended up spending because of this case...
How much was it, Janet?
$1.3 million.
Wow.
This question of whether his education was appropriate was $1 million question.
Yeah.
Wow.
And that's because of, that's not just the tuition, because the tuition is always obviously part of that, but that's also paying the attorney's fees for the parents to fight this because, and this is something that districts struggle with, the IDEA includes that fee shifting, which means going to due process can be a very expensive proposition. Even if you win, right? You still have to pay for your attorneys. But if you lose, you don't have to just pay to provide the education that the court says you ought to have provided in the first place. You also have to pay your attorneys And you have to pay for the parents' attorneys too.
Which is why all of this is so important, and why it's so important for teachers, for school administrators to understand this. It's one of the reasons why there are so many regulations and hoops that you have to jump through, and pieces of paperwork that you have to fill out for this, is because if something like this gets into the court system, it can be an incredibly expensive proposition for a school district.
Yeah. I just also want to talk about, not just the monetary expense, because sometimes school districts have insurance for that or whatever. The emotional and the time,
100%.
the time constraints. I mean, so this case started with, his parents first sent Drew to private school in fifth grade. He was 17 when the case was taken up by the Supreme Court. When it was all said and done, it was years and years later. It was
7
over
years.
a decade. That's all.
Is what I saw.
Yeah, that's all. Oh, 7 years. Okay. So it was all that time, all the emotional stress of it for all people involved, and so to avoid litigation, if you can, is so important.
But not just that, though. This was a child who was diagnosed at 2 years old and who spent 5 years in the public school system not getting what he needed to get before they even started with any of this process, essentially. Right? And so you've essentially got a child, in this case, who has pretty much gone through his entire educational experience not getting from the public school what he deserved, what he was entitled to. The number of students in this country that something like that potentially applies to, we can't lose sight of that. And that's why all of this stuff, like you said, Janet, it's not just about the money, right? It's about the experience that these students are or are not getting in their schools. And on that note, one of the things I wanted to ask you about, Janet, is like the situation that, so Endrew was, 7 years ago at this point? The landscape has changed significantly in schools since then. I'm thinking sort of in terms of the resources that we have available in particular in the special ed realm. I mean, this is a conversation that I'm having pretty much constantly with my students who are, out there in the field, that so many schools just don't have the people to do what the law requires.
Right. Huge teacher shortage for special education teachers and others. Absolutely.
What do you know about all of that? Like, how can you speak to what's going on right now, and what advice or thoughts can you offer the people who are kind of having to wrestle with all of this stuff right now? Like, maybe they know what they need to do, but they can't do it.
Right. Well, sometimes, first of all, learning about the law, so learning about what the legal standard is for across the United States now, that can be empowering. So a lot of times I'll have teachers who want more done, more resources for their students. And so they can utilize the law to be like, we need to provide, appropriate education. We need to provide challenging goals. We need to ensure the students, accessing and making progress in the general education curriculum. It's not that a student should just be being babysat or being, sitting idly by. And so they can use, if they know what the legal standard is, they can potentially, if they're in a district where they don't feel like maybe the supervisors or others are providing them with the resources that they need, they can utilize the law for that. As a society, we should recognize how important it is to fund schools and to, encourage people to go into education, and specifically into special education. As general educators, we should all know that we all are special educators, that the law is going to apply to all of us. As administrators, we should know that our teachers are lacking in legal literacy and lacking in some of the, so it sounds like maybe Endrew's teachers maybe didn't know about appropriate behavioral intervention strategies that maybe they needed to be trained in. So there's a lot of things that this case can teach us to be proactive, to be preventative. We definitely want to avoid litigation, avoid adversarial relationships with parents, and try to utilize the law to empower teachers and empower parents too, to try to get the services that students are entitled to, which ultimately in my mind means that, the funding for IDEA needs to be increased. And as a society, we just need to prioritize education and fund public schools better, because they have so much on their plates. And, even if they don't have the resources, they still can find themselves in hot water if they're not following the law.
Thank you. And that was one of the things that really surprised me when you said it earlier, that, IDEA is a law and it's a funding statute. And it says, it basically says schools, you are required to follow this, but we're only going to provide 14%. Was that the amount that you mentioned earlier?
At one point, and I could be wrong on that, but I definitely know it's not the 40%. And I also know that the IDEA Congress is supposed to reauthorize it for years now.
Mm-hmm.
And other education and other types of federal legislation has taken precedent over it. But, the last time we had a reauthorization of IDEA was in 2004. We are long overdue.
Mm-hmm.
Really? Wow.
And this is, next year will be the 50th anniversary of IDEA.
Oh, cool.
Yeah.
Janet, what about you? Like, what are some big takeaways that you think?
Just so much about that. If it depends on the situation a person's in. If they're a, person who's just listening to this, who's not involved in education, they should be involved in voting and paying attention to education policy. If it's a school leader, they should really be paying attention to what they can do at the building level or district level when it comes to ensuring that their employees are legally literate, and that general education teachers see themselves as special education teachers and understand their responsibilities. That when they get an IEP, it's not to put it away. They need to really understand what an IEP is requiring and what they need to do as educators to implement that. And so it just depends on well, if it's education professors or others, just making sure that we're prioritizing these topics, because just as Chris said, it is the most litigious area. So there's a lot of impact we can have if we're educating people about special education law and policy. And it's not all negative. It can be proactive and preventative. And ultimately, when people know, the purpose behind the law is important for society. We want to provide students with differences. We want to provide them with a type of education that's going to allow them to be most successful citizens, and so if we don't attend to their education needs in elementary school and beyond, then they're going to continue to have difficulties. And as a society, we'll continue to need to provide supports for them. And so if we can be proactive and provide early intervention and effective intervention in the public school districts, then as a society, we all benefit.
Yeah, and I appreciate all of that. And I think that it reinforces that it's not just about the law and the legal standard. When you talked about early intervention, like there's plenty of research out there that reinforces how effective early intervention can be on so many different academic, behavioral, developmental, all kinds of issues. And so, yeah, I guess another way to put it is like, if we can put in the work up front,
Mm-hmm.
we might not have to put in as much work down the road.
Right.
To oversimplify it, if you give this student what they need in kindergarten, they might not need it anymore by 5th grade.
Absolutely.
But if you don't give them what they need in kindergarten, you're going to be providing some degree of services all the way through until they're done.
Mm-hmm.
So,
Mm-hmm.
Maybe spend a little bit more at the beginning to save yourself in the long run, right?
Absolutely.
Well, hopefully what this has done is it has showed you we still have a lot of work to do, which means we'll have more episodes that cover special education concerns. And
Mm-hmm.
like, this is stuff that is current. It's not just like Endrew and 7 years ago wasn't the last of it.
Mm-hmm.
There's stuff going on. I think I read something the other day about something going on in Idaho, maybe. Students with disabilities not being served.
I also know just after the pandemic, more issues with mental health concerns and other concerns. We're seeing more issues related to Section 504 that you mentioned. And so, that's a current topic as well, that the definition of disability and the definition of like what schools need to do to provide reasonable accommodations.
That's expanding.
Is pretty broad. Yeah, it's expanded. Yeah.
Mm-hmm. Yeah, that's a great point. Well, would you be willing to join us again for another episode?
Of course. Like I said, I learn something every time I listen to this podcast. I love it. I love that I can share it with current leaders and future teachers. And so it's a wonderful podcast. And it's such a gift that you and, Jamie and Chris are giving to people to empower them with legal literacy. It's such a gift. So thank you both for spending all the time that you're devoting to this podcast.
Thank you. Like we appreciate that. And we also appreciate just kind of how well you've articulated kind of the goal and kind of the benefits that legal literacy can have. And, that's a large reason of why Jamie and I are doing what we're doing is because we want to increase educated legal literacy, because when you know better, you do better. And you're able to advocate for yourself and your students and their rights and their educational benefits. So like, I know you've spoken a lot on that. And, I think
I'll say too, you feel better. Teachers and administrators are in school employees, they're in a difficult time, a challenging time, and they feel better when, it's not as much anxiety when you feel like you understand some of the tools that might help you get the resources that you need or help you reassure you that you're doing the right thing.
Yeah, absolutely.
Yeah.
Well, thank you so much for those kind words. And thank you for joining us today. We really, really appreciate it. Chris, you want to give everybody the homework?
Yes. So I don't have anything funny.
Do your best to avoid losing $1.32 million.
Yeah, that's a good piece of homework. I did the math. That would pay for 18 years of Endrew's education, which, probably a few more than he needs. But anywho, so avoid losing $1.32 million in a lawsuit. And also find Chalk and Gavel wherever you get your podcasts. Please like, rate, review, subscribe. Also tell your friends if you've got colleagues, if you've got students, if you've got parents or whoever might be interested in knowing more about education law. For all of the reasons that we've talked about today, please feel free to share Chalk and Gavel with them. Your support and you spreading the word is so important to us, and we value it so much. So thank you. Find us on social media at Chalk and Gavel. We'd love to hear from you and continue the conversation.
All right, everybody. We'll see you in a couple of weeks with another episode talking about how the courtroom is connected to the classroom.